Endra and Akwatia High Court issue a bench warrant to say Akwatia MP Yanchen. Na sanse mbe told you NDC supporters the omani aje by MP phones to charge or nani nani said December 2024 election NDC for Kwaji injunction added to Akwatia MP so say when I am sworn in as a member of parliament, but this MP no Obukwat enimtia go ahead my sworn in as a member of parliament. If you want to join parliament, he said he will bear all the consequences and paper. No, and Andra Akwatia High Court issue bench warrant to say we convicting with the police for watching van bra. Na no and Afenyo Markin organize a press conference. I didn't send be to you. And to me, Nketiah and some Afenyo Markin to you our press conference. Nasam, you are lawyer for NDC parliamentary candidate, not the assembly court. You pronounce one December ever to
so we become aware of the Akwatia High Court's decision. We are yet to procure the court ruling and the orders of the court. The lawyers are going to brief the caucus and we will come out with our position on the matter. Meanwhile, I'm sure all necessary steps will be taken to ensure that our colleague is law-abiding and ensure that the right thing is done. But we have to say that we are dissatisfied with the approach and we think that he has been treated unfairly. We would come out fully with our position when we receive full briefing from the lawyers. Thank you very much indeed.
Bernard Bediakon Bedu is a private legal practitioner for the lawyer for the NDC parliamentary candidate for the Akwatia constituency who took this matter to court and indeed the court putting out this ruling today. He moved the motion in court today, as a matter of fact. Counsel, good evening. Thank you for joining us.
Thanks for having me.
Now, you've got what you went to court to demand for. The court has indeed granted you that request, but take us through the specific milestones and the path that this case has traveled to this point. The attempts to get to Enescomi, all of which did not come to any point of response from him.
Okay, so thank you and good evening to your viewers. You would recall that after the elections, and the NDC candidate, Honorable Yadomboache Henry, had issues with the validity of Nketiah being declared, and your partner in the studio helped you with the chronology of events. I need not over elaborate on same. Eventually the matter got to the police training school, and then they were declared winners. The Nketiah, the current Contempt law. We had issues with it, but as law-abiding as we are, we filed the petition, which essentially was challenging the validity of the declaration. Now, together with the petition, we also filed a motion ex parte for interim injunction, and it is allowed in law that if you consider the urgency of the process you are filing such that it will be difficult for you to serve the parties within that period, because you understand that with applications you need 3 clear days before a response could be given and all that. And we are talking about sometime 31st December. If you are filing an application such as injunction and you think you don't have that time where you can have all parties served, the law allows you to come ex parte. And if you file ex parte and it is even granted, it is only for 10 days. After which you at will, if you want to repeat the application, you should do that on notice so that the other party would come to court and be heard as well. So we did that, and it got moved on the 2nd of January 2025. And we convinced the court that there was a matter to be heard. That is, in fact, the underlying factor in granting applications, that you convince the court that there is a serious matter that is supposed to be determined between the two of you. And the court agreed and actually granted our prayer. Now, when the prayer was granted, we then served the order together with all other processes on the contempt no and the Siakumi. Now, when he got the processes, he thought that it wasn't proper. The processes, as far as is concerned, were not properly done, and so he sought to set aside, especially the interim injunction. He filed an application to set aside the interim injunction, which application was heard on the 5th of January 2025, which was a Sunday, and it was pursuant to a fiat that had been given the judge, the learned High Court judge, by the Chief Justice, a copy of which was shared to the lawyers, and I have a copy, that the judge should set on every day until the final determination of the matter, every day, including holidays and weekends. So we were in court on a Sunday, which was on the 5th, and then Neskumi was there himself with his lawyer, Gary Nimako, on the application to set aside the interim injunction. Now, there was this argument, and I had come to court representing the petitioner. My argument was viva voce. When you say viva voce, it was oral, because I had not filed any. I found a problem with, I need to explain this to you so you know what has happened. I had found a problem with the bar number of the lawyer, supposed lawyer, or purported lawyer of Neskumi. I say purported and supposed because he had not filed appearance in the matter, and he needed to file because the CI talks about the rules of procedure with regards to petition, and the rules as stated in the CI that guides the election is the same rules that is used in the High Court, which is CI 47. And CI 47 order 9 says that you should file an appearance before you can even make any case, and he had not. So I had said that he had not filed an appearance, and the judge said no, but I'll still hear him with regards to the application. The application was heard, and I responded. I sought leave of court to respond viva voce orally, and the court agreed with me. So eventually, on the 6th, a day after, the judge ruled that they had not made a case that convinced him to set aside the interim injunction, and so he dismissed the application, thereby affirming the order for interim injunction because it was still in force. That morning, the ruling was around 11. So that morning, 11:12 there. From there, Nketiah proceeded. That was the 6th. So the midnight, he got to Parliament. And then you've seen the videos, what happened there. So subsequently, we decided to file these processes to have him explain to court why he willfully disobeyed the court. And you have said it, that the ingredients of proving contempt basically are 3. The authorities have stated so. The cases that the Supreme Court has determined, the ex parte affoda and then all that.
True.
First, there must be an order of the court. Secondly, the order must specify for the contempt law or the whoever it is directed to know what to do and what not to do. So he should know there should be an order, and he should know about the order, and the order should be specific. That it shouldn't be ambiguous. He should know what he's supposed to do or not supposed to do. And then the final thing is, he should have done so willingly, or he did it woefully. He knew what he was doing, that he knew he shouldn't do it, but he proceeded to do it. All this TV, we were able to convince the court.
I see. But did you at any point try serving him through his WhatsApp and other social media platforms?
Yes, we did. You know, the contempt matters are quasi-criminal. So you can't serve a lawyer. You have to serve the person. That's what the rules say, that it should be served. When you look at
correct
order 50, you should come. You should come order 50 of CI 47. You should serve the respondent directly. You can't serve his lawyer. And you see, let me explain this. I haven't said this anywhere, but I think I need to bring it up before we proceed yet. There are 2 ways we can proceed with this, because this is a very serious matter. It is not just contempt. Because when you recall that the clerk to Parliament on the day read a certain article in the Constitution to him, Article 105.
Yes.
Which says that if you sit in Parliament, knowing very well or having reasonable cause to know that you shouldn't sit in Parliament, you are liable on conviction. That is a criminal matter. That is a criminal, not just the contempt that you disobey the court. It's a criminal matter. And your conviction should be spelled out in an act of Parliament. So when you check section 183B of the Criminal Code to Act 29, it states that if you do that, you are liable for a conviction of and a sentence of not less than 30 days. So there is also that we can, espouse. We can take on. Of course, there are a few issues about double punishment and all that, but we can report the matter to the Attorney General. He takes him on a pure criminal matter that he actually did what he's not supposed to do according to the Criminal Code. But in this case, we chose the part of section 50 of CI 47, which says that if the court can commit you for contempt of the court for disobeying its orders. So in this case, that's what we did. We came under the order 50. So order 50 says that we should serve it on him. Now, service on him was practically impossible. We went to Parliament, they were on break, and we were advised that we should look for him ourselves. So we came to court with an application, ex parte application, to have him served through his WhatsApp and then other social media handles, which we did. But interestingly, well, he could have said that he didn't see it or he wasn't using the lines again. But he asked his lawyer, I won't say his lawyers, because his lawyers, I would not know the lawyers he chose to come and represent him. But lawyer Nimaku came to court, filed processes that the judge should not have proceeded because he had filed a certiorari application at the Supreme Court. So he did not see why the judge could proceed to grant ex parte application to have his client served with the processes. What I take from it essentially is that his client had come to know about the processes. In fact, he had actually told the court by so doing, by that application, that he had been served. And so there was no dispute about the fact that he had seen the application. And so he actually was served through WhatsApp and his other social media handles. Once his lawyers were in court, it was clear that he had been served. But his lawyer's problem was that because they had filed a certiorari application on the petition.
I see. So by inference, you're saying that he wouldn't have filed a certiorari at the Supreme Court if he did not know about the application that you sent to him on WhatsApp?
Not exactly. Let me explain to you. He had filed the certiorari application challenging the order for interim injunction much earlier at the Supreme Court.
Okay.
Now, he was finding it difficult serving my client. Of course, at the Supreme Court, I was not doing a case there. So he needed to serve my client for him, if he prefers me to be his lawyer at the Supreme Court, to serve me or to forward the processes to me. But he is saying that matter was still pending at the Supreme Court. That's what Gary is saying. That matter was still pending at the Supreme Court. So he did not see why, while during the pendency of that matter there, because he was challenging the order. That's what he's saying. So the judge should not have granted the application, ex parte application, to have his client served the contempt processes.
I see. But was there a return date given by the judge for sentencing?
On this, the judge couldn't have, because he would not know when he would be arrested. The bench warrant is prepared. I've seen copies. It's out there. So it will be served on a few people. Parliament would be in the known, and then the security agencies would also, because you see the constitutional injunction of the fact that you cannot serve criminal summons, you cannot arrest when he's on his way in, out, sitting in Parliament. You can't do that. That should be respected. So the only thing is that the speaker should be in the know, because the speaker knows what any MP should be doing with regards to parliamentary duties. So the speaker should be in the know so that he can help us get him. Otherwise, outside the presence of Parliament, the law enforcement agencies should be out there looking for him. And so the day he will be brought to Parliament, to the High Court, is when he would receive a sentence.
I see. But then again, what could be the possible punishment? I mean, for yes, a bench warrant, as you indicated, you've seen that bench warrant now. If things play out, yes, he's going to be jailed. But then again, what other punishment? I've seen a possible fine imposed on him, or the court could just say, go and sin no more. Are these possible outcomes?
Yes, the three are all possible. That is speaking generally. The three are all possible. Jail, but let me explain. Jail, fine, and then a caution. But it depends on the attitude or the posture of the contemptor. You see, when you are accused the way contempts are, what you do is purely a matter of your attitude. What you come to court to show, purge yourself, what we call purge yourself, is what may allow the judge to exercise his discretion in your favor and give you.
But in this instance, he cannot necessarily. Well, he will not opt to purge himself, because that would mean he declining to hold himself as MP for Akwatia. Is it not?
Well, that is his choice, because you see, something interesting happened today. They had written a letter. They said the chief whip for the minority, I'm not too sure. Shaibu, is that the name? I'm not too sure.
Yes.
Had written a letter to court that the contemptor will not be able to attend court because he's attending to some parliamentary duties. First and foremost, in my opinion, you see, that is not a letter coming from Parliament. Parliament is run by the Speaker and the clerk. The caucus cannot, on the instructions of whoever the contemptor, write to the court. That is one. The other thing the judge even said was that he would only read the letter but not even consider it, because in the opinion of the court, he is not even supposed to hold himself as MP. So how can you write a letter confirming to the court, who said that he shouldn't be an MP, telling him that he's an MP and for that matter he is doing parliament? That's quite insulting, because the court said he shouldn't be, and you are telling the court that indeed he is, and he is still performing his duty, so he can't come to court. So the court said, put that letter aside. I'll proceed with my ruling. Right. So you see, it is for him now to either, like you are saying, take the advice, pledge himself that I am no more, and then come to court and say I'm no more the Akwatia MP. But you see, another interesting thing is that the order was for 10 days. And the order expired as far back as the 12th of January. As we speak, there is no current or live order against Neskumi currently.
Right.
You see, and that is why I have a problem with the processes he has filed at the Supreme Court, because it's a shurara on a moot action. But that's a different matter. We will meet him in the Supreme Court. But you see, currently, why he is being punished is because he disobeyed the court order before. That is then, not now. So currently, there is nothing against him as MP. But what he did before is what he's being punished for, because he should not have held himself as such, and he did. And the order was for 10 days, and he did that within the lifespan of the order. And so that is what he's being punished. So he cannot purge himself now. And his attitude, he even filed a motion for the judge to recuse himself, just for granting the ex-party application for him to be served with the processes.
I see.
Then his lawyer came in and all this. And so then the court dismissed that application as well. He filed a lot of things. We will meet him wherever he wants to. But
I see.
This matter,
it's not ending anytime soon. And as you have indicated, you have cited this bench warrant for his arrest. The minority says they are going to consult their lawyers, and then they will give a full detail of what their next step will be. So, Counsel, thank you for talking to us. This is one that, as you've indicated, is just starting. So we would have another date in the coming days. Appreciate you. Bernard Bediako Bedu is a lawyer for NDC's parliamentary candidate for the Akwatia constituency. He has just given us some information that is seen a bench warrant for the arrest of the Akwatia member of parliament, and Neskumi. So this is one that we'll keep an eye on as well.